This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about the importance of the examination under oath, a material condition precedent to every first-party property policy, and why a claim was properly denied for the refusal of the insured to testify at an examination under oath. I spoke yesterday at the conference of the Southern California Fraud Investigators Association on the examination under oath as a tool to help insureds prove their losses and what happens when an insured fails or refuses to testify. This case that I found this morning emphasizes the purpose of my talk to the fraud investigators. Erin Hughes appealed from the grant of summary judgment in favor of defendant and respondent Farmers Insurance Exchange on her causes of action for breach of contract and bad faith arising after Farmers' denial of Hughes' property insurance claim because she refused to testify at a second session of her examination under oath. In Erin Hughes v. Farmers Insurance Exchange, the California Court of Appeals on November 8, 2024 enforced the condition precedent. Hughes is the owner of real property in Malibu. In December of 2020, Hughes obtained an insurance policy to cover the property for fire loss through the California Fair Plan. Also in December, Hughes obtained a homeowner's insurance policy from Farmers to cover perils other than fire, including losses due to theft. 1 month later, in January of 2021, the property sustained significant fire damage. Hughes contacted Farmers, which advised her that the fire loss was not covered by her farmer's policy and she would have to pursue any such claim through the Fair Plan policy. Unhappy, on January 21, 2021, Hughes tendered a theft claim under the farmer's policy, asserting in excess of $2 million worth of personal property was stolen from the property. Farmers ultimately denied the claim on January 5, 2022 on the ground that Hughes failed to cooperate with Farmers' investigation, including by failing to participate in the second examination under oath. 1 week after the denial of her claim, Hughes sued Farmers and alleged Farmers demanded duplicative, onerous, and/or unnecessary documentation of stolen items. Further, she alleged Farmers subjected her to 2 confrontational, accusatory, and grueling examinations under oath. Hughes alleged her second examination under oath had been suspended due to her medical condition, but Farmers disregarded her condition and demanded a third examination. Farmers moved for summary judgment, contending it properly denied Hughes' theft claim based on her failure to cooperate with Farmers' investigation of her claim as well as her material misrepresentations in obtaining the Farmers' policy. In May of 2021, as part of Farmers' theft claim investigation, Hughes participated in an examination under oath, and during that examination, Hughes' counsel informed the Farmers' attorney he had sent more than 40 additional receipts that the attorney would be receiving shortly. Recognizing they would not have time to go through the new items that day, and the examination would need to continue on a future date, the Farmers' attorney proposed continuing to work with one another to identify what's missing, and in response, Hughes and her counsel agreed, with Hughes stating she would be happy to get every single thing that you need and I'll send it to my attorney right away. In October of 2021, a second session of the examination under oath was held regarding documentation Hughes had produced during and after the first session, and Hughes appeared remotely with counsel. But before any questions were asked of her, she objected to a further examination, and Hughes accused the Farmer's attorney of interrogating her like, quote, a fucking criminal, close quote, and stated, quote, if you want to take my deposition, you're going to take a second deposition in court, and that's going to be a formal deposition, close quote. Hughes' remote connection then cut out, and her counsel indicated she would not proceed with the examination. So the second examination had no questions and no answers. Farmers informed Hughes that it was denying coverage based on her failure to cooperate with the investigation, and particularly her refusal to proceed with the second examination under oath. The trial court granted summary judgment in favor of Farmers, noting an insurer has an absolute right to require the insured to submit to an examination under oath as long as the insurer exercises that right reasonably. The court determined Hughes had not shown Farmers acted unreasonably. The court concluded summary judgment was appropriate based solely on failure to cooperate. The trial court properly concluded there was no genuine dispute that Hughes' failure to participate in an examination under oath constituted a material breach of the policy, and accordingly, Farmers was excused from having to pay on Hughes's claim. The right to require the insured to submit to an examination under oath concerning all proper subjects of inquiry is reasonable as a matter of law. An insured's compliance with a policy requirement to submit to an examination under oath is a prerequisite to the right to receive benefits under the policy, and because Hughes refused to cooperate with Farmers' investigation, by participating in completing her examination under oath, she cannot establish her own performance under the policy. The implied covenant of good faith and fair dealing is based on general contract law and the long-standing rule that neither party will do anything which will injure the rights of the other to receive the benefits of the agreement. Hughes' claim for bad faith fails as a matter of law, and in essence, she deprived Farmers of the right to the benefits of the contract. But there, of course, is no bad faith tort when dealing with actions of an insured against an insurer. In my opinion and experience, wildfires tend to destroy everything. That's why insurers are unwilling to write fire insurance in Malibu and other areas prone to wildfires. And the insureds are required to obtain insurance from the FAIR Plan, an organization designed to cover uninsurable risks. Because of the destruction done by a wildfire or a dwelling fire, a $2 million theft loss after a fire is questionable, and a good reason to take a thorough EUO. Farmers tried to do so, and Hughes refused without reason after admitting she left open much investigation documents at the agreed conclusion of the first session of her examination under oath, and then just refused to go forward. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. And you can also receive access to the more than 4,900 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe to the blog and the videos. They're all free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publication for a very small fee. Thank you for your attention.